Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. I'm also here to talk to you about a topic that I'm sure will be of interest to you. So today I want to talk about being here. You are here without status for one reason or the other. Maybe you overstayed, maybe you ended up um, coming into the country uninspected, and now you are trying to fix that situation, right? But you don't have family, you don't have an employer. How can you fix this situation? It sounds impossible. And yes, in some cases, there may not be a solution. But whenever I am talking to individuals and they present this to me, that I first ask them about these possibilities. They don't have family, they don't have an employer who can sponsor them. I am not phased by that because there are possible solutions here that I still need to look for that individual. And this is where I go further into the client's background to figure out what they've been through and whether there's an alternative to get relief for them. Uh, and that's why it's so important to make sure that you schedule an appointment with an attorney who can give you that legal advice. Because as attorneys, we do go more in depth. At least I go more in depth because I also assist my clients with alternative options where they do qualify for it. So, for instance, when I start to ask about their backgrounds, reveal that it may be revealed that they don't have family because maybe they divorced. They were married, but they divorced a citizen, and they divorced that citizen because they were being mistreated. So then immediately what comes to mind is possible VAWA. Now, yes, even after divorce, you can apply for VAWA as long as it has not been more than 2 years since you divorced that spouse. So the clock is ticking. You have to make sure that you follow up and get legal advice to figure out if you do have options even after divorcing a citizen or resident. Other things may come up, like, for example, they may have been mistreated or abused by a past employer, or they may have been mistreated or abused by even relatives or friends or people that at first seemed well meaning and turned out that they mistreated them. In that case, there may be relief through what's called T status if they were subjected to this mistreatment in order to get them to comply with the person. So, for example, I've had cases approved where the relative invited them to come here to the United States to stay with them with promises of getting them their papers. And then when they came here, they quickly realized that they were in a bad situation. So, where they would not get their papers, instead, they're subjected to working for the relative. And when I say working for the relative, I do mean that includes housework, cleaning, the cooking, the taking care of the kids. That is considered work. And in that case, where you didn't sign up for that, you came because of the promise, and now you're being subjected to this. This means that you are in a situation, a trafficking situation. Under immigration law, it makes it very clear that this is a form of labor trafficking. And so you can possibly get your relief through the T status. You don't need this, you don't need to be victimized by relatives, that you could be the victim of strangers. You could be the victim of acquaintances. You could be the victim of a fellow undocumented person who did this to you. You could be the victim of an employer. So the immigration status and the relationship that you had with the individual who did this to you is not going to count here. What counts is what did they put you through? What did they do to get you into that situation? And what did they subject you to? What kind of mistreatment? What did you feel like you were forced or kind of coerced or pushed into doing that you did not willingly sign up to do, but when you're in the situation, you felt like you needed to do it. There's also cases where, as long as you get legal advice, so say you are facing a threat in your country, and say, luckily, fortunately, you have the visa, the visitor's visa. So you head straight to the United States because you need to get away from the threat. And now you know you can't go back. You don't have anybody here. You don't have relatives. You don't have an employer who can sponsor you. What can you do then? If you're fearful to go back, then we look at if you do qualify, if that level of fear rises to the level of asylum, where you can apply for asylum. In that case, you're able to stay here for the time that the immigration officers are taking to consider your application for asylum, and you're able to work while you're doing that. So when I say, in the topic, if you look at the topic, it says, how can I fix my status? Is where you're in a situation where you're here, you don't have the ability to work, you may not be, you may be out of status now, maybe you overstayed because you really weren't sure what to do, and you're trying to get back right with the law. You're trying to get your legal immigration status. So in that case, this is where the consultation is very important. Yes, you may have been through multiple attorneys. I have spoken to people that they've been through multiple attorneys. But in my case, I would say the difference between me and a lot of attorneys is that I screen for things that attorneys don't usually do. If you've been through multiple attorneys, I think you've heard, well, go marry somebody and come back, or are you married to a citizen? If you're not, then there's no hope for you. I don't take that approach. I go ahead and I evaluate other options that may be available that other attorneys are not looking at. So that's the difference between me and other attorneys, is that I am very thorough with the consultation, and I look at all the options on the table to assist you to get right with that, your immigration status. And every immigration status that I am looking at for you, it does involve getting the ability to work here and the permission to stay here. So go ahead, schedule that appointment, go to the link in the profile. When you click on that link, you will see a link to schedule your own consultation, or call the office, and the office will be more than happy to help you to schedule your appointment. My calendar is filling up. So please make sure that if you want this help, you go ahead and schedule it ASAP, make it a priority so that I can help you, because I really do want to help you here. Now I'm going to go ahead and jump straight to your questions. So I see a ton of questions coming in. So I'm just going to work my way through and answer those questions. So bear with me, keep putting your questions in the comments, and I will go ahead and answer. I have a consultation next week with you. I'm excited to talk to you. So I can't wait. So I entered in F1 visa, but did not enroll in school. Now married to a USA citizen. Any chance for an AOS? So the adjustment of status, as long as you enter the country legally and you don't have any other restrictions, then you would be able to adjust status through a US citizen spouse. Now, I don't know what your specific concerns are and what the situation is with you, but this is where, and I'm not your attorney, so this is where it's very important to schedule an appointment and be a little more clear about what your concerns are. However, when you came in with the F1, you came in legally, even though you did not end up going to school. Now, one other thing though that you have to be concerned about here, and this is where I say the consultation is so important. Get that legal advice. Don't skip out on it. Where it's important is, what are you concerned because when you didn't enroll in school, it showed that you never had the intention to enroll, and that could possibly raise some misrepresentation or fraud concerns. If that's the case, then we need to get more facts to see what happened, what the circumstances were, and whether they can imply or they can accuse you of misrepresentation or fraud in not enrolling in school. So this is where it's important to get representation. It matters. I received annoyed. What's the strong document you're recommended for a bona fide marriage case, please? Get legal advice. At this point where you have annoyed is a notice of intent to deny your green card application. And based on what you're saying here, it's because they believe that you're failing to provide sufficient evidence of a bona fide marriage, a real marriage. Now, it's going to depend here. When I get cases like this, I've got cases like this, and we have prevailed. But whenever we get cases like this, it's going to depend on why they are not accepting that you have a bona fide marriage. And we have to address those issues. Sometimes that noid is based on the interview. And if it's based on the interview, we have to look at what exactly was happened in the interview that would make them come to that conclusion, to be able to figure out what kinds of evidence could counter what they're saying. So I cannot tell you that you should respond to annoyed with this document or that document, because this document or that document may not be what you need to overcome that annoyed. Now, yes, if you get a notice of intent to deny, it does not mean that your case is denied. It means they're giving you a heads up that in the next 30 days, they will deny your case unless you timely respond, and give them a reason why they should not, convince them that they should not. So, my advice to you is get representation ASAP. I was approved for the I-765 and I-131. What happens next? You'll get, hopefully, if you're approved for them at the same time, a combo card. The I-131 is a travel document. The I-765 is a work permit. Usually you get that within a week or two, and you're able to then work on that while your case goes through, whatever your case is. Right now, they're issuing 5-year work permits and travel documents. So that puts you in a state where you can be rest assured while your process is going through. Now, another thing here is that um, the social security number is also issued along with the I-765 if you stated that on the application. If not, you have to go to the Social Security office to get your social security number as well. My I-113 work permit processing time both says 1 week. Is that accurate? So I'm not sure where you're seeing your processing times. So, I don't know. Usually it could be the I-130. The average is about 9 to 12 months, but I'm not sure where you're seeing 1 week. Um, What if they wrote no AOS in the passport upon entry? Now I'm married and want to start filing. So we just got our client. So our client, the same thing happened. They said no AOS in the passport. he got the green card in the mail. So it's going to depend though on the situation. I would have to understand the facts associated with the no AOS. Sometimes they write that in the passport, especially when they're restricting the time that they've given you to stay, like they make it shorter than the 6 months. But it doesn't mean that you'll be denied. But what I'll say is get legal advice and representation to make sure everything goes smoothly. EAD renewal was sent in April and I didn't get it, and it expired in November. Is it late? Um, so I'm not sure what the situation is there. So if you sent in your renewal and you haven't received, if you received your receipt notice, the receipt notice does have an automatic extension of 6 months. So now, my lawyer said she filed for both work permit and Social Security, but never got the Social Security. Don't worry. So she didn't get the Social Security number. Sometimes that happens. It's not usually the lawyer's fault. Sometimes there's just a disconnect. In that case, go to the Social Security office and apply for your Social Security number. They'll go ahead and send you a new one within a week or two. So no worries there. It's not something that's not replaceable. Can I file for adjustment of status on my own out of status? So if you're saying you don't have any family, don't have any employer, you don't have any other types of status that would allow you to, then the answer would be no. But if you have family members, you have now there may be ways, but it has to be through employment, through investment, through family. If you if if you don't if you don't qualify through any of those ways, then you're not going to qualify. All right. Let's see here. I'm gonna go ahead. All right. Can you hear me? Okay, so no audio. I just had a technical glitch here on Instagram. So let me just fix this for a minute. All right, so here I am. I'm on Instagram again. I had technical difficulties, so bear with me. Thanks so much for your patience. So I'm going to go ahead and answer questions on Instagram. So put those questions in the comments as I. So thanks so much for joining. Had technical glitch. Please go ahead, put your questions in on Instagram so I can quickly answer your questions before we have another technical issue. Put those questions in the comments. What if I overstayed because of a court case? How can I fix this? You need to, usually if you had a court case but you overstayed, that's usually not an excuse for overstaying. We have to figure out though the facts here to determine what happened. Quickly put your questions in the comments on Instagram. I want to make sure I get to your questions before we have another issue here. Fiance visa, please. I don't know if that means what that means, but I'll quickly let you know what a fiance visa is. So if you're outside of the United States, you're the fiance of a US citizen. Only US citizens can file for this. That US citizen can petition for their fiance. So that, in a nutshell, you have to show the intention to that you will get married within 90 days of coming to the U.S. on the visa. You do have to show that you've met in the most recent 2 years before applying, and if you've not met in person, you have to show you have to show a very good reason why. You have to either show extreme hardship or show that there's some kind of cultural a tradition that prevents you from meeting before you get engaged. So that is a summary of the fiance visa. I have an employer. Can I file for a green card that way? If the employer is willing to petition for you, yes. How long does it take to get the approved for the I-360? If we're talking about I-360 through VAWA, it's going to be about 3 years. Now, keep in mind that you do have the ability in most cases, not every case, to apply for the work permit while you wait. What if I overstayed after coming on a work program? Can I adjust my status outside of getting married? It depends. This is where the consultation is going to be very important. Now, your options become limited, but we have to understand your facts to see if you do have that option. How long does a petition what? Well, I'm not sure what this is saying. I think that it's mistyped. You're probably trying to rush off the sentence. How long, how long does a petition go after filing for the green card if I married a US citizen? So my shortest case has been 5 months. And then I would say the longest is a little over a year, but on average, most of them are 8 months. How long does it take for USCIS to respond after receiving RFE evidence? So it could be a few weeks to even months. How long does it take to get receipt notice after filing VAWA? Could be 2 weeks, could be up to 6 weeks in the busy time. What if I overstayed after coming on a work permit? So I answered that. Will a felony automatically disqualify me for adjustment of status? Was married to a citizen for 14 years, but he passed from cancer. Give us a call. It's not automatic. I mean, there may be ways to apply for a waiver if it does. So if the felony does disqualify you, make you inadmissible, there may be ways to apply for forgiveness. Give us a call. Let's talk about what this is. I need to understand what charge it was to understand maybe if there are going to be severe immigration consequences or there's a way to overcome any inadmissibility that you have. Getting food stamps for my daughter who was born here. Mom, out of status, will that affect getting my green card? The food stamps are for your daughter, and so your daughter's a US citizen. It should not. And then they just released the policy manual that details that food stamps alone will not disqualify you from getting the green card. I'm over 21 years old, children living in Jamaica, eligible through me. Are my over 21-year-old children? Yes, but it might be a 5 to 7 year process, and those children have to be unmarried. If you're a citizen and they're married, it takes much longer. It takes 12 years. Filed VAWA April 2021, got combo card for prima facie notice. How long for a decision? So I'd say about 3 years right now. What's your immigration handle? So I'm immigration lawyer Sharifa on Instagram if you'd prefer to join me there. But I say you can stay here. I'm answering your questions here on YouTube as well. But if you want to follow me over there when we're finished, definitely go for it. My employers refuse to consider the automatic extension. I lost my job. What do I do now? Give me a call. Let's talk about what happened with your employer to see if there was more to it where you could get relief. Hello, my family member came on a student visa to be a doctor. She did not complete, instead got a degree in computer science. Since then, she had 2 kids. Is there any way she can gain status? Not through education alone. I mean, since she has an overstay, that could complicate the issue. But I need to understand exactly what happened, what her circumstances are. There may be options here, but I have to understand it. Hi there, Lindy. So nice to see you as usual. I applaud and appreciate the effort you make each day to educate and inform. Thank you so much. I appreciate that, and I'm gonna keep doing that. All right, can I file for adjustment of status on my own while out of status? No. Can you? It depends. For example, my T status clients can adjust status on their own. That's their status. They don't need anybody to file it for them. VAWA, yes, if they qualify for those. And this is where I need to get your facts. Go ahead, schedule the consultation. Now on YouTube, Facebook, Instagram, go to the description of the video. No, YouTube, Facebook, Twitch. Go to the description of the video, click on the link, and you'll be able to see the link where you can schedule your own consultation. On Instagram, go to the profile, click on the link, schedule your own consultation, or call the office through the website. On TikTok, go to the bio page. You'll see the link there. Go ahead, schedule the appointment. My schedule is filling up. And if you want to get the help, I want to help you, but you have to take the steps to get the help. Go ahead, do that so I can talk. All right. I have a little bit more time, so I'm going to just answer a few more. Can I file my I-485, I-130 at the same time and submit my medical with them? They're actually encouraging you to do that because what will happen is you may just get your green card in the mail if they decide that they have everything they need to. So submitting a strong application along with a medical can mean that you'll get the green card in the mail because they may waive your interview. Let's see. I'm a green card holder. Can I file my wife's green card together with my citizenship? If you're a green card holder, if your wife is in status, the priority date is current, then yes. This is where it's important to get a consultation. Otherwise, if your wife is out of status, then you'll have to wait until you get citizenship before you file for her. Do children being filed for still do medical when they get to us? So it depends on the process you're talking about. Usually they do the medical from the country that they're coming from. It just depends. Say they're paroled and then they go through the adjustment of status process here, then in that case, they would do the medical here in the US. Mom filed for me in a long time ago, but I aged out. Can I still qualify for T245I? Now, if at the time, usually the application to qualify for T245I, the application that was filed has to be approvable. It means it has to be an application that would have been approved, but for one reason or the other, it wasn't. So if your mom filed a petition that was never going to be approved, then you wouldn't qualify under 245I. So that's also something you have to look out for when applying under Section 245I, which I can do a whole live on Section 245I. It's where if you've been filed for on or before April 30th, 2001, even if the application didn't go through, but it was approvable, then you can you can otherwise apply for adjustment of status in the future rather than leaving the country. What if I overstay in the States and don't know what to do? How can I get a work permit and resident here so I can live here? Schedule an appointment. Let's first talk about your circumstances and then determine what the best way would be. Can I file for my spouse and kids if I get an employment-based green card? Yes, so that's usually a possibility to apply for your wife and kids. Can a person, and the kids have to be under 21 and unmarried, can a person apply for tourist visa while on filing? It's possible, but you have to really come good with your evidence that you qualify for a tourist visa. All right, that's going to be it for me. I'm going to aim to be back at around lunchtime to answer some more questions. So look out for me. Thanks so much for your time, everyone. Now, next week, I'm going to be running some promotions, handing out free consultations, and also launching discounts again. So look out for that next week. Continue to join me in the lives, and you will hear how to get that done. So thanks for your time. We'll talk tomorrow again. So until tomorrow, bye-bye.